This is Sports Radio 1140, The Fan.
Talkin Money!
And we're back to Talkin Money with your host, Jeff Tarbell.
Just call me T-Boone Pickens.
T-Boone.
Or just call me his heir. I don't care what you call me. That was the quiz winner. Number one athletic supporter for Oklahoma. $165 million.
$165 million.
And even T-Boone is having some financial issues. Some of his accounts and things have had some ups and downs. And so some of the projects he's committed to are on hold now. But
yes.
So even at that level, you can get a little bit of a topsy-turvy. So, hey, we're talking with Jeb Burton, Jeb with the Burton Law Firm in Sacramento, talking a little bit of asset protection. And during the break, we always have our best conversations during the break. But our cookie provider came in and said, if she runs into somebody and well, sadly, hurting them really bad is a whole lot worse than killing them in many cases. But if you run into somebody, and John was talking about a friend that he knew in Arizona, is a similar thing where an auto accident, whether you were drinking or an accident or however it happens. But is there a way? What is the mechanism for not the people that have $10 million that can afford to move 8 of them into the Caymans and live off of 2 of them while they mess around, but the person who just says, hey, I got some. I own my house free and clear. I got some good equity here. I got a few bank accounts, here. And yes, they're in a revocable trust, but stuff happens, and and she pulls out there and smack, hits a little kid or something on the road, or something happens. I mean, it happens. Is she wiped out?
That's a good question. There's some things built into the California law designed to protect those individuals. The first thing was one of the issues we were talking about in the break was the Homestead Protection rules in California. You have the right to be able to protect a certain amount of equity in your home from a third-party creditor, but nobody has equity in their home anymore, so it's kind of a...
Well, this individual does.
Yeah.
And it's a small amount. It's like $75,000 or something, isn't it?
That's correct. It is a small amount. If you're married, it's a little bit higher, but it is a small amount, and frankly... you can have your home sold out from under you if you have enough equity in it that homestead will be protected and your creditor will be partially paid for. So it only provides certain protection. The first thing I'd say to anybody in those scenarios is you want to be maxing out, and you want to do this anyways, max out your retirement, your Roth IRAs, your 401k plans. Those are very protected, and those should be one of the first things anybody's doing from an asset protection standpoint to make sure that those are maxed. What
about an income stream from like a pension or something like it? So let's say, I'm a retired teacher, retired cop, or whatever, and I'm getting $5,000 a month for life. It's not a pool of money. I don't get a statement that says you have $35 million in here, you can take $5. I'm just getting $5,000 a month. So I injure somebody or I'm sued. Can you win a judgment and say, well, we're getting 4 and you're getting 1?
The answer is it depends what you're being sued for is the first thing. If you've got anything dealing with fraud or certain acts, as I mentioned, drunk driving a second ago, there's certain laws that allow you to be able to attach assets and things that are normally protected, such as pensions, and go after them. Then the second thing is you most likely, and I shouldn't say most likely, you should be able to protect basic living needs. So you'll be able to not get attached to the point that you cannot pay for basic living needs.
So my basic living needs is a Ferrari, 2 girlfriends, and a big boat, and an aircraft. And I mean, who decides what my basic living needs are? The way I've been living the last few years, or basically living in a box down by the river?
Very similar to the way the IRS figures out what your basic living needs are. And let me say that they assume you don't need much.
Yeah, because they continue on taking it from me. Yeah. Okay. So we did mention a couple other things there. You mentioned some of the LLCs and that.
So the term asset protection, and I do a lot in the estate planning community. I'm pretty well known, I think, in the estate planning community in Sacramento. And asset protection is generally one of these dirty words that nobody wants to talk about in the legal community because it promotes negative concepts. That's changing.
Because people think they don't think they're going to die, or they think that you're trying to hide something.
Well, they think, well, what are you doing? Are you trying? You're stealing money? You're hiding it from somebody that
Okay.
you should be paying these loans. So that terminology kind of promotes this negative idea. And I personally, and I know there's been a national movement trying to change the concept on this. Frankly, when you create a LLC over your rental properties, so that if somebody sues you when they slip and fall on your rental properties, and they can't attach your personal assets, which is very common if done appropriately, that is a form of asset protection. There's things you can do beyond that point in that LLC. If a third-party creditor, you have a couple co-owners that LLC with you, and a third-party creditor comes in and sues that LLC, and once again, it was done appropriately, there can be protections built into the LLC that would reduce that creditor's ability to be able to get money only to the money that the LLC normally would pay out to the shareholders. And to the second step, there's some even greater protections that can allow the remaining shareholders to buy out your interest after that creditor takes control of the shares at a vastly reduced amount. Therefore, you're protecting the other investors in your business as well.
So let's talk about the LLC for just a minute, because so I have a couple 3 rentals that aren't worth a damn thing, but they do leave me hanging out there that someone could get hurt on them.
Correct.
And I own them in my trust.
That people often put them in a revocable living trust because they conceive that there's some asset protection in that trust. Well, as I mentioned earlier, revocable living trusts really don't provide any asset protection in this manner. I'd say, in my opinion, the better way to handle this, and there's an argument whether or not a very large umbrella policy is a better way to do this, but in my opinion, taking those 3 rental properties, putting it in a limited liability company, and then making sure that limited liability company has insurance on it to the point that it would cover a reasonable creditor. If for some reason you get way beyond that insurance amount, some vastly crazy jury or whatever, some freak accident occurs, that person suing you within the LLC, they're suing the LLC. They generally can't attach you personally. So your house and your other assets are going to be protected. You might lose your 3 rental properties, and
please,
yeah, whatever's insurance is there, but you're generally going to protect the remainder of your assets.
In fact, I'll give anybody the address they want to just go burn it to the ground. I mean, that's fine. So now I already have these, and I've had these for a long time. So you don't want to get into this fraudulent. Is it too late for me to put them in an LLC now, or there's nothing going on, there's nothing wrong? Could I go do it now?
Well, that's a good question. There's a number of things you got to think about before you do that. The first thing you got to think about is, do I have a mortgage on that property? And by transferring into the LLC, am I actually causing a problem with the mortgage?
Right.
Where the lien holder has the right to be able to take that asset because I've defaulted essentially on the mortgage by transferring.
Again, please do. So you're right, because in the lending world, we don't loan to LLCs, we loan to individuals. And so you could be almost like a due on sale clause if you transfer title of an asset, a home, to an LLC. You've technically sold, quote unquote, from an individual to a business, if you will, a business entity. That's
correct. Now, I would mention that this is not legal advice, but I've very rarely seen creditors, and I have seen it happen, where the creditors actually care, as long as everybody keeps making the mortgage payments.
Right.
That being said, I wouldn't make that as a legal recommendation. The second issue you got to think about is, when you're making that transfer, is there some existing creditor? Yes, you can probably make that transfer to the LLC if you're just that investor who's got the house. But if you're being sued by somebody that just slipped and fell in the house, or it's being threatened to be sued by the guy that just slipped and fell in the house, and then you go throw it in the LLC, that might be a little late.
Yeah.
And there's, you have to speak to an attorney, because there's always.
I am speaking to an attorney.
Yeah. in an individual case, everybody says they're always looking for a one-handed attorney because they can't say on the other hand.
Right.
So each specific factual case is different. So you need someone to look at that particular matter and tell you what you can and can't do.
And there's one other big advantage to LLCs, and I used to use this when I was buying and flipping houses and actually building houses and selling them, is that when you hold these properties in an LLC, you're not subject to having the withholding. The state will withhold taxes, even if you have not made a profit. They'll assume you have, then you have to file for your money back at the end of the year. So you'll see a lot of people that are buying, land and putting a house on it, or buying a property and flipping it and doing those kind of things too, particularly without a lender involved. They're doing it within the LLC format because of the state of California's withholding requirements. And if you've run into that and all, it doesn't apply to your principal residence, but it does apply to investment properties. The state will keep your money. And they say, well, we know you're going to owe us taxes. Well, I didn't make any money on this deal. Well, we don't care. You can file for your refund at the end of the year. We'll talk about it then. So it does get you out of a way of giving the state of California free money.
Yes,
so
that's absolutely true. One other thing I'd mention, though, is before you throw that in the LLC, you should talk to your CPA as well, because there's potential tax consequences. Did we lose? There's potential tax consequences to doing that. The first one being is if you fall under the small investor rules, such as you own a couple houses and you're able to write off that what we call passive activity loss, the losses on those the losses on those homes, then there's a chance by throwing in the LLC you might no longer qualify for those tax deductions. So there should be a conversation with CPA or tax attorney before you do that as well.
Okay. Grant, we have to take another break, or 3 minutes till the end? Oh, okay, gotcha. I'm sorry. I thought we were due for one break. Apologize there. So I mentioned during this client that came in this week and was talking to him about the Revocable Trust, and it shocks me how smart people who have done very well throughout the years of acquiring real estate or building something that has good equity in it and do all these things, how their intelligence cuts off at a certain point, or their willingness to do a little research. And I had an individual this week who came in who had hundreds of thousands of dollars of equity in properties, if not damn near $1 million in overall property, and this stuff was just titled in his individual name at 80-something years old. And I mentioned to him, if we're going to do some kind of financing or some restructuring here, let's put it into trust at the same time, because we're going to have to go through some title paperwork anyway. And I didn't seem to trigger any kind of, that's a good idea. And I thought, well, the comment was, we can do that whenever. And I thought, unless you know the exact day, time, and minute you're going to die, now would be a good time to do that, because if you don't do that on your own, the state of California would love to do it for you.
Actually, I'm not sure that's true. The state of California is overloaded at the moment on those particular issues, but they will do it. It'll cost you a lot of money, and it'll take a long time. An estate worth $500,000, and when I say $500,000, I mean the fair market value of the assets, not ignore loans. In Sacramento and the surrounding surrounding counties, will run roughly $26,000 between attorney's fees, the fees for the personal representative, and the court fees to go through probate, and it'll take a little over a year.
And that's if none of the heirs want to contest it or fight over the different money too. So that's the beauty of the trust, is you can lay out the path. This is what I see. This is my money. This is where I see I want it to go. I don't want it to go to my two sons. They're jerks, and they can go. It can skip over them and go to their dogs. So I'd rather have the dog have the money than have these two. So I mean, it gives you a path. And it gives a blueprint, and it's everybody says, well, this is expensive. Well, hell, you haven't seen expense yet until you put it in the California. So anyway, Jeb Burton at the Burton Law Firm, Burton. Thank you so much. Appreciate it very much. This show will be on a podcast. If you want to catch us again, it'll be on our Talkin Money Facebook page and the JeffTarbell.com site, so you can re-listen to it, or just copy it and send it to somebody, or send it to your family if you think they should be dealing with that too. So that's it for another Saturday. Johnny, thank you. Jeb, thank you very much. Have a great weekend. Be safe out there. We'll catch you this week at JeffTarbell.com. We'll see you next Saturday, buddy. Aloha.